Okay, we are live. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone, and welcome to the May 7th sitting of the Massachusetts Appeals Court. My name is Mary Thomas Sullivan, and along with Jeffrey Kinder and James Lemire, we will be your panel today. We are hearing 4 cases today, and we will go straight through. In between each case, we will go offline briefly, and if you are watching remotely, you can just stay online and we will return. Even though we are live stream, we will follow the same rules as if we were in our usual courtroom. That is that each side has 15 minutes to argue. There will be no rebuttal. The justices will ask questions. I only ask from time to time that counsel take a pause because sometimes there's a little delay. You may want to give us a moment to come in with a question without interrupting you. The proceeding is live and being recorded, and anything said during the proceeding will be heard by all of those observing and become part of the record, just as in a physical courtroom. And if there are any technical problems, if anyone inadvertently drops out, we will take a brief break and we'll suspend momentarily in order to get our feedback. And for those of you who have an impounded case, remember to use the pseudonym. I would be remiss if I didn't, before we began the sitting, extend the panel's thanks to those who have made this virtual sitting possible, our clerk of court, all of those in the clerk's office, and our law clerks who have worked so hard to make this live stream oral argument possible. And with that, we'll call the first case, 19P 1223, Rosario versus Caring Bees Healthcare, Inc. Counsel, you may proceed.
Thank you, Your Honor. Good morning. May it please the court. My name is Eric LeBlanc, and I am here on behalf of ANAIS Rosario. In this case, an employer is countersuing his employee for making reports of sexual harassment to human resources, a coworker, and her own mother. This is clear retaliation by litigation and risks the broad protections of General Laws Chapter 151B provided to employees and victims of sexual harassment generally. Mr. Carangua's novel counterclaims, if not dismissed, will eviscerate and render meaningless the comprehensive remedial scheme of 151B. Considering this and applying the anti-SLAPP standards within the context of 151B, this court should reverse the lower court's decision and dismiss Mr. Carangua's counterclaims in their entirety. This case comes down to 4 statements, Your Honor. And all of these 4 statements are protected specifically by Chapter 151B. The 4 statements, one was made to a human resources officer, Ms. DeBarros, regarding a video that contained inappropriate sexual content sent by the boss of Caring Bees, Mr. Carangua. In addition, it included a second comment from Ms. Rosario to Ms. DeBarros regarding an alleged touching by Mr. Carangua, the owner of Caring Bees Healthcare. In addition, it includes a statement to a coworker, Karen, regarding the same touching. And it also includes a statement to Ms. Rosario's own mother regarding the touching, where she was asking her mother for advice on making a police report. Chapter 151B, as I've said, is a comprehensive remedial scheme. And coming from that context, Section 9 of 151B says that it must be construed liberally and inconsistent laws should not apply. In addition, Section 3A deals specifically with sexual harassment claims. It requires employers to have a policy, investigate claims of sexual harassment, allow employee participation in those claims, and it strictly forbids retaliation for making of those claims. And again, the statute is liberally construed. If this is allowed, employees in Massachusetts will have fear for reporting. It'll not only chill, but it'll put a deep freeze on any sort of reporting and commenting to HR, to coworkers, and to one's own family to gain support relating to sexual harassment claims.
Mr. LeBlanc, can I interrupt with a question on that point? You seem to be arguing that Chapter 151 preempts, in a way, any sort of anti-SLAPP motion in this instance. Are you suggesting that, or preempts rather counterclaims, are you suggesting that in a case of an allegation of sexual harassment, there cannot be counterclaims?
Well, Your Honor, there cannot be counterclaims as they're phrased here. And if you look at, again, the Thomas case, the Thomas v. EDI case, which the SJC decided, there are certain claims which are restricted in sexual harassment cases. In that case, it's a contribution claim. So the question there really becomes, if an employer can't sue a sexual harasser for contribution, why would an employer then be able to sue a victim of sexual harassment? So yes, we would say that, but there are other mechanisms both within 151B and within the civil procedure to deal with these issues. 151B, because it's so comprehensive, has a provision in it providing for sanctions for false claims. It also has a provision in it for criminal liability for false claims. In addition, we have the idea of perjury, because all MCAD charges need to be signed under the pains and penalties of perjury. And to the extent it gets to court, there's 231(6)(f) and Rule 11. So there are remedies, just not these particular counterclaims.
Are there any cases that go so far as to suggest that counterclaims of this type are prohibited under Chapter 151?
This is a novel case, Your Honor, quite frankly. With respect, we've done our search and we can't find any other cases in which an employer has actually made a countersuit against a sexual harassment victim.
If I may follow up, part of the difficulty in this type of case, of course, when it comes up on a SLAPP motion, is that we're at a very preliminary stage and we're supposed to not resolve factual issues. And there is obviously a credibility question in this case. She says something happened. The employer says she's making it up. Hypothetically, if one were able to fast forward and imagine a situation in which it had been proven that the claim was false and knowingly and maliciously false, are you saying that that type of claim is also preempted?
I would say it's, number one, preempted at this point, Your Honor. But I would go so far as to say the way that the 151B scheme is made and the way that the MCAD is made, any claims of sexual harassment must be made within 300 days. So presumably, to the extent that that was proven, the counterclaims would still remain ripe at a time when the allegations were found to be maliciously false.
Except if it's a mandatory counterclaim, it would have to be brought at the same time. And a 3-year statute would apply, and perhaps the case would be within 3 years, it wouldn't be.
But again, this isn't a novel situation, Your Honor, because the similar, again, the more comparable case is the Thomas case with respect to the idea of contribution. That has the same, same idea with respect to a 3-year statute of limitations, as well as removing a common law claim because it doesn't fit within the legislative scheme of 151B. In addition, Your Honor, just to address a further point on anti-SLAPP motions, the defendants do have a factual burden. It's not, we're not talking about just a 12b6. Under the anti-SLAPP statute, the defendants do have the factual burden to make the showing through affidavits or other factual evidence that that they meet their burdens under the analysis.
Of colorability, not that they would prevail.
Understood, Your Honor. Understood.
Mr. LeBlanc, before you go further, you mentioned 12B6, and I just want to clear up a procedural point. The judge denied dismissal on two grounds, one the anti-SLAPP motion and the other under 12B6. Are you appealing her decision with respect to 12B6? And if so, how is that issue properly before us?
The issue is properly before you because the anti-SLAPP motion is before you, and I think the court has broad discretion to determine whatever issues are currently pending.
Well, I agree with respect to the anti-SLAPP special motion to dismiss that interlocutory appeal is appropriate. It's less clear to me why denial of a 12B6 would be an appealable order. Is it in this case?
Well, I believe it is, Your Honor. I think that the issues are very intertwined. And if you got rid of some claims pursuant to anti-SLAPP or some claims pursuant to 12B6, you could potentially get rid of the entire counterclaim.
Thank you.
So again, with respect to the statutory construct, this will lead to fear of participation by other employees, and Section 4 specifically allows that type of communication. Section 4 protects communication to other employees as well as third parties, such as Ms. Rosario's mother. And quite frankly, Your Honors, part of the issue is Ms. countersued for making complaints of sexual harassment. Under 151B in the Supreme Judicial Court's case law in both Collegetown and Galakian, there is a prerequisite to reporting allegations of sexual harassment to both human resources, potential coworkers, and 151B specifically allows concerted effort between employees to stop sexual harassment in the workplace.
Mr. LeBlanc, you have
counsel. Go ahead, Judge Kinder.
You have on several occasions referred to Ms. DeBarros as the human resources officer. That seems to be a matter of some dispute in the record. What is your record support, other than her own affidavit, that Ms. DeBarros is a human resources officer?
Yes, Your Honor. And under the number one, it would be Ms. Rosario's affidavit. But number two, under 151B, the company is required pursuant to Section 3A to have a person whom sexual harassment can be reported to, and to have standalone sexual harassment policies. Because the company did not do so, and because Ms. DeBarros was the one person who Ms. Rosario believed was an HR representative, the burden would shift to the company to make that showing.
Are there any cases, Mr. LeBlanc, that hold that statements to third parties, for example, co-workers, or in this case, a family member, are considered to be petitioning activity?
I believe the North American Expositions case, Your Honor, it was a threat to sue to a third party, as well as the Biogen IDEC case. That was a little different. It was a demand letter. But pursuant to those cases, internal complaints, which are a prerequisite to liability, would be considered petitioning activity because they are meant to influence, inform, or at least reach a governmental body.
And were these internal complaints or simply conversations with coworkers?
Well, specifically to Ms. DeBarros, it was a complaint. Ms. Rosario believed that Ms. DeBarros was a human resources professional. With respect to her coworker, it was an attempt to obtain concerted activity under Chapter 151B. And
Counsel,
obtain
I
participation. Because
go ahead, finish. Were you finished?
Yes, Your Honor.
I understand reporting something and maybe even forewarning coworkers, but we have to put this in context with the affidavits that were submitted that are indicative of a potential scheme here to obtain funds on a false report. Are we supposed to ignore that in assessing how she spoke to other people, or is it included in our analysis?
Well, Your Honor, under the Benoit case, dueling affidavits are not found to even when the opposition affidavits are based on personal knowledge, are not found to to counteract the affidavit of the, in this case, Miss Rosario. So the Benoit case does.
I'm not trying to make a determination of the facts. It's just that the allegations go beyond a mere reporting, according to the defendant. So it's not just she reported it to HR and she reported it to a coworker and she complained to her mother. It's based on other aspects of the allegations by the defendant that this was done in an attempt to obtain funds by making a false claim. And I just assume I'm not trying to knock out certain aspects of either affidavit. It's part of the analysis is the way I'm assuming.
Well, it is part of the analysis, Your Honor. And when we look at the affidavit submitted by defendant, they are rife with problems. There are repetitions, there are the same misspellings. It doesn't look as though the affidavit submitted by defendants bear any sort of authenticity, number one. But number two, we have an employer who is in a position of power over these employees seeking affidavits. They're in an inherent power battle. And quite frankly, who's going to win? It's going to be the employer who has these employees' livelihoods in their hand.
But is that something we have to evaluate at this stage, or is that more apt for whether it's summary judgment or a trial?
No, I think it's in light of the anti-SLAPP standard and what the defendant's burdens are once we get beyond the first step, we arrive at a situation where the affidavits do need to be looked at. But again, with the Benoit case, it says that the defendant's affidavits, even if based on personal knowledge, do not trump the plaintiffs in this case. Your Honor, really quick, one other piece. Just the lower court did not have the benefit of either the second Harrison case or the second Blanchard case, which put forth new standards. And I think most particularly, the new standard of whether or not the claims were colorable by fair assurance. In footnote, doubted that Mr. Karangwa would be successful on his claims. As a result of that, in and of itself, we know for a fact that the lower court was not sure of its decision. Thank you, Your Honor. For these reasons and the other reasons in my brief, I would submit that the the lower court's ruling should be reversed.
Okay. All right. Thank you very much. Counsel, you may proceed.
Thank you. The Suffolk Superior Court did not abuse its discretion or commit a clear error of law in denying the special motion to dismiss. The counterclaims do not arise from internal complaints of sexual harassment, did not stem from a complaint to the police, and didn't stem from an MCAT complaint. The basis of the counterclaims are four, which you heard my brother indicate to you. A knowingly false publication to a coworker that the appellee sent the appellant a pornographic video of couples engaged in sexual intercourse that shocked and terrified her. Number two, a false statement to a coworker that the appellee grabbed the appellant's vagina, a felony indecent assault and battery. Number three, a knowingly false statement to appellant's mother that the appellee grabbed the appellant's vagina, a knowingly false statement to a coworker that the appellee was a molester and a pervert. The Suffolk Superior Court considered all the pleadings, all the affidavits, in order to apply the proper legal standard to consider the special motion. These pleadings included a finding of no probable cause in the district court for an alleged indecent assault and battery, 5 affidavits from coworkers disputing all of the appellant's claims.
Counsel, we're very familiar with the record. But if you could, we are not in a position, and the Supreme Judicial Court has been pretty clear with us that we're not in a position to resolve these kinds of credibility disputes at this stage of the proceeding. And there is clearly a a very substantial credibility dispute. And so if you take that out of the equation, if you take the quote unquote knowingly false out of the equation, could you recalibrate your argument and explain to us why you think the judge was correct?
So the judge was correct because she properly applied the Duracraft standard as augmented by Blanchard 1. The May 7th, the decision was May 7th of 2019, 1 year ago today. The Harrison decision was included in her analysis. Harrison 2 was decided November 8, 2019. And in reading that case, it provided no additional retroactive legal guidance that the judge, anything different the judge would have made under that case.
Can I
What-
stop you on that? I'm sorry, go ahead.
Go ahead. Justice Kennedy.
You say it added nothing, but it seemed to emphasize the importance of the judge making a sequential determination of the various stages under Duracraft and Blanchard. And your brother makes the argument that that sequential analysis didn't happen here, and that in fact was error. Can you respond to that, please?
Sure, and I looked at that in a decision. The judge basically stated that she didn't decide whether or not the complaints were SLAPP suits. I'm sorry, she did not decide whether or not the, hold on one second, I'm sorry.
Whether the counterclaims were petitioning activity.
Yes, exactly, whether or not the counterclaim was petitioning, but said assuming that it was petitioning and then went forward to her next analysis. So in fact, the appellant got the benefit of the doubt without the court deciding, which I believe if the court had decided that it wasn't petitioning, it stops there. And there's no need for the further analysis. So
And are there, speaking of petitioning, are there any cases that talk about statements being made to third parties, family members, co-workers, that qualify as petitioning activity or supportive of petitioning activity?
I'm not aware of one single case in the Commonwealth, Your Honor. And I think some of the cases that the appellant referred to have dealt with, I forget the case that he cited. There is a case that indicates, I think it may have been the one that he cited, where statements were made to the press that were in anticipation of a complaint. The complaint was actually pending and they were discussing that complaint. Also, there are cases that include demand letters where they're stating facts in a demand letter and threats of litigation. That's not the case here. In this case, we're dealing with statements made to co-workers that were not, and they weren't even made as internal complaints of sexual harassment. These were statements made to co-workers that had nothing to do with administrative aspects of the business.
Well, you say they had nothing to do with it, but in fact, they were the exact same statements that were later made to the police and within the body of an MCAD complaint. So they are clearly similar.
That's correct. And when I say nothing to do with, I meant to say that they weren't made as internal complaints of sexual harassment, because as it is in the appendix, there is a policy and procedure for sexual harassment. Contrary to what counsel argued, DeBarros was, who was one of the employees, she answered the phone. She was not a director of the company. All she did was answer the phone. She was not in human resources. So these were discussions that were made with co-employees outside of any type of complaint aspect, Your Honor.
Do we not have to accept her affidavit that she thought that Ms. DeBarros was a human resources officer?
Well, I think that we'd be going back to whether or not, the court is going to consider the credibility of the affiance, and it's a factual issue.
Well, it's possible for us to decide for purposes of these motions to treat both sets of claims as colorable. We don't have to resolve the dispute. We just have to say, for purposes of our analysis, we take it as we find it.
That's correct.
in that respect, in terms of what constitutes petitioning activity, in Blanchard, the Supreme Judicial Court held that statements in a newspaper to the general public were petitioning activity. So if that's the case, why would statements to coworkers not be petitioning activity?
I think for a couple of reasons. The statements, there was no, in the case that Your Honors, and I don't recall all the details of the case, but I believe that the statements made to the media and the reporters, there was petitioning activity active at that time, and those statements related to that petitioning activity. In this instance, we have an individual that are making these false statements of fact to individuals. There was no petitioning activity at that time. Petitioning came later.
Perhaps, but does the timing, and that's true in this case, but does the timing matter? If I'd like you to postulate a hypothetical, I understand that this is not your view of your case, but if somebody has a legitimate good faith basis for believing that they've been a victim of discrimination, are they then not permitted to go to their coworkers and say, this happened to me, has it happened to you? Before they file as part of their assessment of whether or not they have support if they do file.
Certainly they could do that, but I would argue to the court that that would not be considered petitioning under the anti-SLAPP statute, because a coworker is not a governmental entity. This is pre-petitioning activity.
Well, but if it's in aid of your petition, which is what Blanchard says the statement to the press was, so that your petition is effective, why would that same analysis not apply to pre-petition activity?
Yeah, I think it would contrast the clear language of 59H, because that statement is not made to a governmental entity. There's no petitioning involved at that time. And one thing that I think the court should consider, if in fact an individual was allowed to defame someone with impunity, provide false allegations, and then there was a legal claim presented, could that person then just file a police report, file a complaint with the police or administrative body, which would then authorize them to have made those discussions previously? I think we would be going down a slippery slope, and I think it would be contrary to the clear language of the anti-SLAPP statute, which says the statements have to be made in the course of petitioning, which are the protected statements.
Counsel, do you want to respond at all to the argument that 151, Chapter 151 essentially preempts counterclaims of this sort in any sexual harassment case?
I'm going to be honest with the court, is I don't fully understand that argument. I really don't understand how it would preempt an alternate cause of action that someone may have. Certainly the appellant would have a right to file a sexual harassment claim under 151B, but there's nothing in my reading of the statute or the case law that would state that that would preempt any other claim from being filed based upon that behavior. They're distinct individual claims. The appellant had an opportunity and did file an MCAT action under 151B and voluntarily chose to withdraw that action and took it out of the administrative process. As one of the justices mentioned earlier, it's not counterclaims or any claims are not compulsory in that administrative action. Certainly the appellee has a right to file any claims against the appellant that the appellee has. And once the appellee removed it and filed in the Superior Court, then it becomes compulsory, and the appellee had to file any claims against the appellant at that time.
Counsel, are you familiar with the Syed versus Klein case decided by the SJC in 2011 about retaliatory counterclaims or claims?
Offhand, I apologize, Your Honor, I'm not.
Okay. Go ahead.
Thank you. The Superior Court held, even assuming without deciding the appellant statements were petitioning, which I say they were not, the special motion must be denied because the appellee demonstrated the counterclaims did not give rise to a SLAPP suit. They were not brought to chill the appellant's petitioning. The Superior Court correctly ruled the appellee's primary motivating goal in bringing its claims was not to interfere and burden the appellant's petitioning rights, but rather to seek damages for its personal harm. The Superior Court applied the standard and considered the totality of the circumstances relevant to the appellee's asserted primary purpose in bringing the claims, the course and manner of the proceedings, the pleadings filed, and the affidavit stating the basis and fact for the claims. The court considered whether the appellee's claim was colorable. The Superior Court considered the entire record and stated it was satisfied the primary goal in bringing the claims was not to interfere or burden the appellant, but to seek damages for the harm suffered. The court correctly noted the claims were not classic SLAPP suits.
Counsel, could you point to us in the record where damages are identified other than nominal damages for defamation per se?
Damages in the complaint.
I know there's a plea for damages, but in your presentation before the Superior Court judge, what damages do you claim flow from the plaintiff's conversation with her mother, A, or B, the plaintiff's conversations with coworkers? What damages have you identified?
So the damages identified, which we did discuss during the argument before the Superior Court, were the humiliation and embarrassment that was caused by having facts that published that you're a molester and a pervert, and that you committed.
Is that with respect to the conversation with the mother or just the conversation with the coworkers?
With both, Your Honor.
How does the plaintiff's conversation with the mother cause the defendant humiliation?
Because the publication to the mother indicated that the appellee grabbed her vagina and thereby committed an indecent assault and battery. How many people did the mother?
Until the claim was filed, did the defendant even know that such a conversation had taken place?
Prior to the claim being filed, yes. So in addition, the judge did discuss damages, and the judge indicated that the allegation that an individual commits a felony, indecent assault and battery is in fact damages per se.
Well, it appears your time is up.
Thank you, Your Honors.
Thank you both.
Thank you, counsel.
Thanks, counsel.
Okay, we are live.
All right. This is the case 19P0848, Predny versus Town of Winchester. Mr. Predny is appearing pro se. You may proceed. Ms. Predny,
Mr. Predny, go right ahead.
go ahead.
May it please the court. I am Miroslav Predny, the plaintiff appellant. I will leave the factual background. I apologize. I hear the echoes.
You may want to turn your volume down.
You could also not close out of the YouTube version if you have that open.
Whenever you're ready, sir.
You want to
Yes.
try again?
Okay. I am Miroslav Predny, the plaintiff appellant. I will leave the factual background in response to claims made in the appellee's brief to the paper filed earlier. Here I elaborate on the main argument. Plaintiff seeks a revote of an invalid 2019 override question and seeks a ruling from the court preventing similar invalid votes in the future. Defendants, appellees have three basic problems. They misrepresented the override amount and the tax impact. They conflated three dissimilar override funding purposes into a single override question and misrepresented it as a purely operating budget override question. They failed to timely disclose the planned override to residents. Now to the first argument. The override was presented to residents as a special 12 million override stretched over 3 years. See appellant's brief, page 34 to 37, or record appendix, page 16. In fact, it was a disguised general override with cumulative use of 28.5 million spread over 3 years. 6.5 million first year, 10 million second year, and 12 million the third year. And after that, the third year, the cumulative increase of 12 million would become part of the tax base forever. Select Board Chairman Grensback presented to residents the 10 million portion of override amount earmarked for operating budget as a, quote, one-time lump sum authorization, end of quote, and, quote, a credit line that would be drawn down as 4 million in fiscal year 2020, 3.5 million in 2021, and 2 million in fiscal year 2022. At that time, you basically exhausted what you can draw down, end of quote. Record appendix 113 to 115. Thereafter, Select Board member Golubov explains the total override tax impact on residential property valued at 1 million will be $1,570 spread over 3 years in decreasing amounts. $850 in first year, $450 in second year, and $270 in third year. See appellant's brief, page 38 through 41, or record appendix, page 18.
Mr. Predny,
Defendants misrepresented the general override as a special override. The voters were misled and confused.
excuse me,
Now to the
Mr.
second
Predny,
argument.
Mr.
There
Predny,
should have been 3 separate override votes.
Mr. Predny, you need to stop if one of the judges wants to ask a question.
Mr. Predny, can you hear me?
Yes,
I would like to ask you a question. I don't mean to interrupt your argument, but procedurally, you filed a motion for a preliminary injunction that was denied.
yes, I can hear you.
Okay, there's a delay. And your motion was denied for a preliminary injunction.
Yes, correct.
The court then entered dismissal as the matter being moot because the vote occurred the next day.
Correct.
And you, a number of days later, filed a motion to reconsider.
Yes, correct.
It's my understanding you're appealing the motion to reconsider.
I'm,
What do you understand that you're appealing?
there was a period of time I could have filed the motion to reconsider. That
You filed that 28 days after the dismissal.
I apologize. I have to let you know that when I talk, I hear interfering with my talk echoes. I hear interfering echoes. But I understand that I filed a motion to reconsider less than 30 days after it was denied, and then I file. I'm appealing the denial of the motion to reconsider. That's correct.
Okay, thank you.
Can I proceed?
Yes.
Yes, please.
Second argument, there should have been 3 separate override votes. Defendants deliberately, in violation of statute, combined 3 dissimilar override purposes into a single vote on one question. Their illegal purpose was to induce an artificially higher yes vote. Voters who normally would support only one of the purposes, by voting for their purpose, are supporting all 3 dissimilar purposes listed in the override question. See appellant's brief, page 95 through 98. This tactics is called log rolling, and it was previously misused by Town of Winchester Select Board in 2002 override vote. See record appendix pages 460 through 64. Massachusetts Supreme Court rejected in 2018 ruling the use of this practice in the Christopher Anderson and others versus Attorney General and others case, and ruled in favor of plaintiff. See addendum page 87 through 115. Moreover, the defendants also presented the 12 million override with tax levy increases phased in over 3 years, and later changed to 10 million phased in over 2 years. Hence, they turned the 2019 override also into a multi-purpose, multi-year override. Pursuant to General Law, Chapter 59, 21C, and DOR guidance, a multi-year override with funding for dissimilar purposes requires a separate ballot question vote for each year and for each override type with dissimilar purpose.
Mr. Predny, did you make this argument and the first argument in the Superior Court?
At that time, it was only about a week before the hearing, before the vote. So I was trying to write the complaint, and this information wasn't available to me at that time because of the short period of time between when I revealed this behavior and the hearing.
Mr. Predny, I just want to make you aware, because you're not a lawyer, that we do have a general rule in this court that we do not consider arguments for the first time on appeal, that we typically consider only the arguments that were presented to the motion judge. So in the balance of your time, if you wish to, and we're happy to listen to anything you want to say, but in the balance of your time, you may also want to make sure to touch on what you said and what you wrote to the motion judge.
Okay.
You can go ahead.
Okay, to the motion. Okay, so The motion is plaintiff seeks annulment of the 2019 override vote and new vote on each of the separate purposes, and a ruling that instructs the defendants to take corrective measures with respect to future override votes. That's my motion. I would like to also complete the argument. During the lower court proceedings, I filed a complaint about the irregularity of the and misrepresentations of the vote. This is reference in let's see, I'm trying to locate that. If you read my original complaint, which is on I'm claiming defendant request this honorable court to issue temporary injunction on the proposition 2.5 override ballot question voting until corrective remedies are being implemented. Issue a judgment against the defendant, ensuring defendants will enact corrective remedies in compliance with the existing laws. But I would like this to be treated as a de novo argument in the appeals court, because some of that information was not available at me at that time. I requested the records from the Superior Court proceedings. They came 3 weeks late, and I asked for the records from the town meeting, and they were made available to me much later, sometimes in May, I believe. So the information wasn't available at that time, but I think that there are exceptions to the argument of mootness. I'm telling you, I would like to make the argument against the mootness, and it is as follows. One of the exceptions for mootness concerns the ability to challenge short-term conduct which may recur in the future, which has been denominated as disputes capable of repetition yet evading review. Thus, in cases where the challenge action is too short in this duration to be fully litigated prior to cessation or expiration, or there is a reasonable expectation that the same complaining party would be subject to the same action again, mootness will not be found when the complaint of conduct ends. The plaintiff repeated this same action in 2000 of log rolling in 2002 and in 2019. So therefore, there is a reasonable expectation that there will be a precedence that this log rolling, which was rejected by the Supreme Court, will be repeated in the future. Therefore, the mootness doesn't apply. There is a looming controversy here. I am the taxpayer. My taxes were increased. My tax increase in 2020 were 210% more than the tax increase in 2019. So I'm directly affected by the action of the plaintiff. So the float override irreparably harmed the plaintiff and all the Winchester residents who were misled about the purposes, the magnitude of the impact, and who were forced to vote up or down on 3 dissimilar override purposes in a single question.
Okay. Well, thank you very much. Well presented. Attorney Anderson?
Good morning, Your Honors. My name is Austin Anderson of Anderson Krieger for the defendant appellee, Town of Winchester. In our brief, we addressed several procedural and jurisdictional issues that are sufficient to dispose of the appeal, but I would like to begin this morning by emphasizing the point that's at the heart of the matter, which is that on the facts, Mr. Predny's claim has no merit. The fundamental issue here is straightforward. It's whether the ballot question that the town used in its election last March complied with state law. If you compare the ballot question to the statute and to the Department of Revenue's guidance, you can see that they match. We included DOR's guidance in the addendum to our brief at page 42, and it gives examples of proper question forms for towns to follow, including listing all of the purposes that the money will be used for. The town followed the guidance, and it did so in consultation with DOR. The town did this correctly, and there's no reason to disturb the vote or the judgment below. This is what the Superior Court recognized when it denied the preliminary injunction. Mr. Predny's claim has no likelihood of success on the merits because the ballot question complies with state law. And also, just to anticipate one potential remedy open to the court, there's a remand in this case would be unnecessary and a further waste of taxpayer money. The Superior Court had everything before it that it needed to look at in order to decide on the merits, and the record on appeal contains all of that information. Again, it's a straightforward matter of comparing the ballot question to the statute and the DOR guidance. There's no further information that could be developed through discovery at the Superior Court that would aid in a decision. I'd also like to emphasize that the relief that Mr. Predny is seeking for the first time on appeal to overturn the override vote would be enormously disruptive to the town. This vote took place over a year ago, and all of the budgeting decisions made by the town in the past year have been made in reliance on it. Because this argument wasn't raised before the Superior Court, this information isn't in the record, but Winchester's police, schools, public works, and every other department have developed their budgets after last year's votes and relied on the money available through the override to hire special education teachers, police officers, crossing guards, as well as to negotiate contracts and pay raises with union employees. So if the vote were annulled or if that money were put into question, the town would be forced to fire their new employees, renege on their union contracts, and especially while dealing with the state of emergency around COVID, it would have a devastating impact on the town. But as I mentioned, the procedural and jurisdictional issues that we address in our brief are sufficient to dispose of the appeal. There are 2 reasons that the court does not need to reach the merits here: timeliness and standing. But even if Mr. Predny were to clear those hurdles, the Superior Court's decision was correct. As Judge Lemire pointed out, the judgment actually being reviewed here is the denial of the motion to reconsider after the case was dismissed. Just very briefly on the timeliness, this is set out in our brief at page 9. If the judgment entered on March 27th, as the Superior Court docket indicates it did, then this appeal was late. It had to be filed by April 26th. It wasn't filed until May 9th. Mr. Predny argues that the appeal period should start May 1st with the denial of his motion to reconsider, but there's nothing to indicate that the judgment entered that late. If you look at the online docket attached to our brief, at the end, there's a case disposition section that lists March 27th as the relevant date. In addition to the fact that the appeal is untimely, Mr. Predny does not have standing to bring this claim. As this court knows well, that standing implicates the court's subject matter jurisdiction and the power to decide the case. There's no private cause of action under the statute that Mr. Predny relies on, General Laws Chapter 59, Section 21C, and there's no basis to imply one here. In the case law, the touchstone for implying a cause of action is legislative intent. And there's no indication that the legislature intended to create a private cause of action here, especially where the Department of Revenue has been given extensive oversight and regulatory authority. DOR already has a process for ensuring compliance with the override procedures under Chapter 59, Section 21D. The Commissioner of the Department of Revenue has to review and certify on an annual basis the tax rates for every town in Massachusetts. And part of that is ensuring the tax rate complies with Proposition 2.5, including any override amount. The town has to submit documents to prove that it complied with the override procedures in order to make that money available. Beyond the lack of a private cause of action in the statute, Mr. Predny also cannot meet the prudential requirements, or the requirements for prudential standing. There's no particularized harm here. As he says explicitly in his papers and mentioned again today, he's bringing this claim on the behalf of all taxpayers in Winchester. His situation is identical to every other citizen in town. Further, any of the injury he's claiming is speculative. He's referred to higher taxes, but the relief he's seeking is to change the ballot's wording. And there's no reason to believe that a change in the ballot's wording would have changed the outcome of the election. The ballot question passed by a wide margin, about 20 percentage points, and there's no evidence of the voter confusion that Mr. Predny is speculating about as to whether it was a permanent or a temporary override. Just would like to note as well that the fact that it is an override rather than debt exclusion itself indicates that it's a permanent override. There's no such thing as a temporary override. But even if Mr. Predny were able to clear the timeliness and standing hurdles, the Superior Court's judgment was correct in substance. The motion to reconsider was filed after the case was dismissed as moot because the relief that Mr. Predny sought could not be granted. Before the Superior Court, the only thing that Mr. Predny asked for was to change the ballot's wording before the election took place. After the election happened, it was not possible to grant relief, and so the case became moot. He didn't talk about overturning the vote until after his case had already been dismissed, but the court was well within its discretion to deny his motion to reconsider, even if the court wants to construe it liberally as a motion to amend the relief sought. At that point, the Superior Court had already looked at the documents and made a determination on the merits that the town's question complied with state law. So any amendment would have been futile. The capable of repetition yet evading review exception he refers to also doesn't apply here for two independent reasons. The first is that this case is not capable of repetition. The issue is whether the particular wording of this specific ballot question complies with state law. Any future ballot questions will have different wording, and analysis of whether they comply will be an independent issue. In addition, this case does not evade review within the meaning of the exception. The exception is intended to apply to disputes that by their nature have a short life expectancy. But this case became moot because the relief that he sought could not be granted, not because the nature of the alleged violation makes it impossible to review. I just want to touch very briefly on a couple of the arguments raised during the presentation today. As Judge Sullivan pointed out, these were not raised in the court below and should not provide a grounds for reversal. But in any event, they are also without merit. The town is required by the statute to list all of the purposes for which it will use the override money. So including the multiple purposes does not violate the statute, is in fact compelled by the statute. In addition,
you could have had three separate matters and voted on three separate matters. And this is not an uncommon debate within towns, whether it should be a bundled ballot or a separate ballot, right?
Yes, the town does have discretion to organize it that way if it wishes. If it can split the money up as far as it wants to, if it wants to have the money for the police department be a separate question from the money for the school department. But there's nothing in the law that compels the town to do that. If they want to present the question as an all or nothing proposition, they're able to do so. And the statute and DOR confirm that. Briefly on the misrepresentation allegations, I just want to clarify. I believe that Mr. Predny's confusion is stemming from the fact that this override was approved a levy limit increase of $10 million, but the town was not planning to use that money within the first year. So when he talks about it being phased in, when the chair of the select board gave his presentation talking about it being phased in over 3 years, he meant that the town was only going to use some of the new capacity in the first year, and then the rest of it would be phased in over 3 years. So it wasn't a multi-year override. It was a one-time increase in the levy limit of $10 million, but the town doesn't have to appropriate that money immediately. It can do so over time. The remainder of Mr. Predny's arguments are addressed in our brief at pages 17 to 20, and we're content to rest on the papers unless the court has any specific questions.
I have nothing.
Thank you very much then. Thank you both. This concludes argument in this case.
Thank you, Your Honor.
Okay, we are live.
Please the court, Adriana Condratesi for the respondent appellant mother. Before I begin, I would just like to thank the court, thank the tech support, and also especially thank Anthony Dorr downstairs in the clerk's office, who is always accessible and available to resolve a problem at the last minute. In this case, 4 reasons demand a remand for review of the visitation issue, and justice so requires that, and mother requests it. The first reason is that at least as of July of 2019, the children were not living with Aunt Jay. By July of 2019, Aunt Jay had returned the children to DCF. The second reason is that the court found that there was a significant attachment between mother and the 2 girls. And the court found that the best interests of the children required visitation. The third reason is that Aunt Julie was a person where there was abundant evidence that she would be reliable to safeguard that best interests of the children and ensure that they would have that contact with mother that the court also found was in their best interest. And the fourth reason is that those interests are not now being safeguarded. And the reason that we know the remand is necessary is that in the court's orders, and that's on R254 of volume 1 of the record, at paragraph 8, the court said, if the placement with Aunt Julie is going to change, I want to be notified immediately. That never happened. And now the court is entitled to exercise its discretion to order visitation, knowing what the full facts of the case are. I have a few.
Counsel,
Yes, Judge.
is it in the record, and I neglected to remind everybody at the outset that we're using pseudonyms, but is it in the record that the children are no longer with Aunt Jay, or is that a development that is subsequent?
Well, it's in, I believe that it's in the docket entry sheets that attorney Tatum Long had submitted to the court in her record. And the court, if not, I can submit new docket sheets that will indicate that as of July of 2019, that had happened because some post-trial motions had been filed by trial counsel relevant to that issue, but there's not one docket entry that shows that DCF had notified the court of that change.
I don't have the date of the decision in front of me. Is that development post-decision though?
Well, the interesting thing, Judge, and thank you so much for reminding me, I wanted to make that point. The court's findings issued in April of 2019. And this mother and father's counsel went back to court to notify the court about this and to ask for some other kinds of relief. So it might very well be that at the time that the court was considering those post-trial motions that mother and father had filed, DCF already knew that Aunt Jay was either giving up the children or had already given up the children. The court's findings issued in April of 2019. I know the earliest date I know that the children were returned was July of 2019. So it may very well have been in the works. Certainly the adoption
Well,
social worker would have known that Aunt Jay was sick and contemplating returning the children.
That wasn't the purpose of my question. The purpose of my question was to determine what is properly before us and what is not properly before us. And typically, although not always, but typically, post-judgment conduct is for post-judgment proceedings.
Well, I do want to remind the court, I know the court knows this, but I will remind the court that the appeals court can take notice of docket entries even when it's only a related case. And I have a few citations if I can offer those to the court.
But I mean, we'll certainly take your citations, but how is that argued before us today, other than you bringing it up now? It wasn't argued in your brief. And it wasn't an appeal from anything that occurred in the trial court.
Well, what my brief really focused on was essentially all the reasons why, without Aunt Julie in the picture anymore, there's nobody to safeguard that visitation. And that little girl is now 9 years old. The older one is now 9 years old, has leukemia, and has not talked or contacted, not text, called. The mother has no clue where she is. And that, you know, for the court to have found that there's a strong bond that child who was sick is someplace that they don't know who mother is, they don't care, they're not interested. A 9-year-old kid might be afraid to tell her new family, look, can I please get in touch with my mother? So this is something that the court specifically said, I want to know if that.
I saw that in the judge's order. I saw that he wanted to know if there was any change there. And the reason I reiterate this is, isn't this a matter more that should have been brought before the trial court?
Well, it was, Judge, but it was to some degree. But the point is, and I have a few cases that this has happened where DCF failed on its heightened responsibility because of that notation in the court's order, failed in its heightened responsibility to notify the court so that the court could go back and exercise its discretion on the visitation issue with a full set of facts, where this has exactly happened. And the most recent case is adoption of Orrin.
But does the order specifically ask DCF to notify the court? I mean, if
Oh, yes,
the mother
it does,
was,
Judge.
all right.
Oh, yes, it does. At R
But it doesn't
254.
it does not prevent any other party from notifying the court.
Well, no, it doesn't, Judge. But if you are postulating that is going to absolve DCF of its responsibility, I don't think that it's the same. And neither did adoption of Terrence or adoption of Orrin, the most recent case that followed Terrence. That didn't change the picture for that remand either. It's DCF is the only person that's standing there to safeguard that best interest of that visitation. And, you know, with a 9-year-old who's sick, this isn't even a matter that she's got to drive hundreds of miles to see mother. This is just a matter of maybe the court would want to know, yes, look, she should be able to text her mother. She should be able to FaceTime her mother. They should be able to play a computer game together. Maybe she has a few questions. I think that this is something that the court really needs to know about.
All right. Counsel, your time has expired. Thank you very much.
Thank you.
Thank you. May it please the court, I'm Madeline Blanchett, and I am representing Father this morning. Father asks that this court vacate the decree terminating his parental rights for a few reasons. The lower court erred in finding that termination of father's rights was necessary. Aired
The perils of the landline. Thank you.
It's no
Go ahead.
worries, Your Honor. The lower court erred in finding that termination was necessary. And these errors are the following. Number one, the court failed to weigh the fact that prior to father's incarceration, he did have a very positive and connective relationship with his older daughter. The court failed to acknowledge that when father was in prison, he accessed visits to the best of his ability, and those visits, no one disputes, went very well. He showed a strong bond with the children. And then for a very important issue, which is briefed in the reply brief extensively, the court misinterpreted 210 section 3 little Roman numeral 8 to basically punish father for his prior incarceration, when in fact the plain language of the statute says that the child will be deprived of a parent for a period of years. At the time of the trial, father had either 6 months of time left to serve if he was not granted parole, and then just maybe 2 to 3 months if he was able to get parole. So this is a case where, there were quite a few findings, but only 17% of the findings related to father, and the primary area that the lower court focused on was father's incarceration. And that error in interpreting that statute, which is very clear, requires that order to terminate to be vacated.
This was not father's first incarceration, correct?
That's correct, Your Honor.
Was the judge permitted, I take your point regarding the language of the statute. Was the judge permitted to consider a pattern of incarceration for similar offenses in determining his availability in the future?
Your Honor, the judge was entitled to consider a pattern of incarceration. They were not entitled to hang the termination entirely on a criminal record or incarceration. And I think that Attorney Tatum Long, in her reply, really briefed it well, saying that that the goal of the criminal justice system is to rehabilitate defendants. And so the record is clear that father took part in many programs. He took part in parenting. And in fact, his moves throughout the prison system were into successively less restrictive confinement. So I think that is, that those things all point to, this is a father, while he was unavailable at trial, it does not rise to the best interest of the children to have his rights terminated. And I would say that really segues into the fact that that there was a failure to really follow the best interests and the statutory framework, because the judge, while she did say at the end of the trial that she would hear from father about his alternative plan, which we know under Dora and other cases that has to really be entwined into the best interest termination analysis, and then failed to do that. And so I know my brother acknowledges that was a mistake, but says that it's harmless. And I just really want to point the court's attention to the judge's ruling in her adjudication, where they say under 9 that the lower court denies consideration of father's plan. So it's not that it's, and I mean, that's the truth. There's no findings about the plan. There's no application of best interest. There's no comparison of the two plans. The court acknowledges I'm actually denying consideration of father's plan. And I would say that that is another clear error of law, and it deserves vacating the termination and at least a remand where father could participate in that proceeding. And then,
You know, Counsel, if I could just briefly, there is an entry in the Assembly of Record docket, which is slightly different than the docket that's in the appendix, but it says 11/20/18 hearing on merits held. So I was a little confused as to what the status of that was. It doesn't reflect it in the other docket, but it's in the Assembly of Record. It says hearing on merits held. And that was the November 20th date.
Your Honor, my understanding is that the parties did assemble that day. They were in court, but then no hearing was held. And then even within that appeal period to complain about that, then the adjudication was issued saying no hearing will be held.
Okay, thank you.
I confess to some confusion because I believe some of the other briefs suggest that father didn't actually propose a plan. Could you respond or illuminate that?
Your Honor, father's plan was guardianship with his mother who had had custody of the children before.
But did he submit a proposed plan?
That was his plan that he was going to litigate through her guardian, or alongside her guardianship.
Was it formally submitted in any way to the court?
Your Honor, I did not brief this case, and I have to confess that I don't know that level of specificity.
I think that's what Judge Sullivan was trying to.
Thank you. Yes. All right. Well, your time is expired. We've run over a little. And I don't know who has elected to go first, be it Attorney Bayless or Attorney Sullivan.
Yeah, I will, Your Honor. Excuse me. May it please the court, Jeremy Bayless for the Department of Children and Families. I'd like to just begin by addressing some of Mother's points, several of which were raised for the first time today. The evidence that was provided about the children's situation following trial was obviously not before the judge at the time that they made their decision and the time when they weighed the plans. However, what was before the judge was the potentiality that the pre-adoptive placement might not work out, which is why the department's plan included as a secondary tier recruitment in the event that that family did not, that the aunt was not successful. So the judge has already considered and weighed a potential plan of recruitment in making their decision. There's no need to remand for a new consideration. And if mother feels that there is an issue with the current placement, she has both the ability to take that before the trial judge, either through motion practice in light of the court's order, or at a permanency hearing, which are held regularly for the express purpose of analyzing the permanency plan that is currently working for the children. It is not appropriate in this case for this court to assess error in the judgment below due to factual changes that happened after the judgment occurred when there's other remedies for those to at least be addressed. I believe my sister will have a more accurate and up-to-date understanding of the children's current placement if your honors have more questions about that. But with regards to mother's overall position, at the time of trial, she admitted that she was unfit to care for the children, and she didn't contest the government or the department's permanency plan that was put forward, except for the extent to which it led to termination. The fact that she is now in her briefing attempting to contest both of those things, those arguments were waived below. With regards to specifically visitation, there is strong support in this record as to why a structured visitation order would not have been in the children's best interest. One of the major reasons would be what my sister focuses on in her argument, the fact that the older girl has leukemia. She has significant medical needs and regularly scheduled medical appointments, providing a visitation order that mandates a certain amount of visitation only creates the potentiality of conflict there, particularly when there's no evidence that any of the caretakers are opposed to working with the parents for visitation. There's no evidence at all, because this is a development that happened after trial. To turn to father's positions, with regards to his incarceration, father overstates the extent to which the court relied solely on incarceration. The court specifically discussed the fact that father was involved in co-parenting the children during the period when the older girl's medical needs were not being met. Father's service plan, as acknowledged by the court, specifically directed him and mother to ensure that the medical needs of the children were being addressed, and the court expressly found that that wasn't done. Failure to meet the medical needs of the children, completely unrelated to incarceration, is an appropriately considered factor in determining fitness. Additionally appropriate, as Your Honor acknowledged, is father's history of incarceration, father's pattern of criminal behavior, and in fact, consideration of the fact that he was incarcerated. While father did take some actions while incarcerated to improve his parenting, the ultimate fact that was presented to the judge was he was unavailable to the children, and he had been for close to years at the time of the trial. And while it was not necessarily father's fault that he was not receiving visits consistently, in child welfare matters, fault is not the operative factor. The operative factor is what is in the best interest of the children, and is the father able to, going forward, do so. Given father's lengthy criminal record, the judge was properly within its authority to determine that father had demonstrated that he was not likely to continue to cease from participating in criminal activities. He already had reduced custody access, and the custody of the children had actually gone to his mother due to conflicts in the home, and there was cocaine brought into the home and kept in a chest that was accessible to the children. There's ample evidence that father's ongoing behavior was not likely to change, despite the fact that he had participated in some services while he was incarcerated.
According to the 51B reports, it's mother who said she brought the cocaine into the home. Is there anything in the record that suggests, and I appreciate the fact that we've got convictions of both of them, but is there anything additional in the record that suggests that father was aware that that's where the cocaine was?
So, I mean, as Your Honor noted, the big one is the conviction. Father received a more severe sentence, which would indicate some evidence that he was complicit. Additionally, it's hard to imagine that a father who has a lengthy criminal record, specifically for trafficking cocaine, would have just coincidentally had a baggie of cocaine, a decent quantity of it, kept in his home without his knowledge.
I understand the inferences. I was just asking if there was anything expressed in the record.
I don't believe there's anything.
Okay.
Father didn't expressly say that this was mine. Mother attempted to claim full responsibility there.
And the police reports aren't in the record, right?
I don't believe they are, no. There is, however, related to that point, there is, however, a lengthy discussion in the 51B report with the paternal grandmother, where she lays out and explains her position or her denial of responsibility for the drugs being found in the home, which goes to whether or not father was prejudiced by the whole kerfuffle over being able to present evidence for his plan, because father did not formally submit a plan. Admittedly, he'd asked for continuance to do so, but at the first continuance date, father continued not to submit any evidence, be it the written home study that he claimed to have access to, or call any witnesses, or give any indication that he had arrived at that hearing prepared to call any witnesses, nor after that February or November 20th date failed to occur, did father take any action in the 10 days between the hearing date and the date that the adjudication entered to either make an offer of proof as to what his evidence would have been, to seek a new date for in order to present his evidence. So what the court had before it was a lengthy amount of delay in the proceedings, an already accessible and usable summary of what the paternal grandmother's response to her violation of the conditions of custody that led to custody being revoked, In light of those facts, while the court should have acted differently, father was not prejudiced to the point where remand is necessary. And I see my time has elapsed, and so if there are no further questions, I'll rest on my brief. Thank you.
No further questions?
No.
Okay. All right, we'll wait for the timer to reset. You may go forward. Thank you.
Good morning. My name is Amy Solins, and I represent the appellee children. Child number 2, Jada. Jada is 8 years old, and child number 3, Journey. Journey is 3, about to turn 4. And on behalf of the appellee children, I am asking this court to uphold the judgment of the lower court in its entirety. If I could speak to some of mother's arguments, I say in my summary of argument, what this case really is about on appeal is an impermissible attempt by the mother post-termination to direct the future of these children. And she doesn't have any standing to do so under the adoption of Scott. As was noted by this court, she also did not brief the issue of visitation. And I would just echo what Attorney Bayless said about why it is appropriate in this case, considering the medical needs of Jada, for that visitation to occur at the discretion of the adoptive parents, who would be in a much better position to know what her current situation is. With regard to, move on to address some of the father's arguments. In terms of father's argument that the court over-relied on his incarceration and misapplied Section 8 of the statute, father is arguing for a strict interpretation of the statute and asking this court not to look beyond the plain meaning of that statute. And I would suggest there is ambiguity in that statute as to when this period of years begins to run. And if you accept father's interpretation of that statute, he's asking this court to ignore a serious conviction. And I believe would frustrate the purpose of that statute, which is to advance the best interests of the children, if the court adopts that interpretation of the statute. In addition to the statute, our common law has recognized an adoption of Frank, care and protection of Frank, that criminal behavior that bears on parental fitness is appropriately considered. And here, where we have a father who is selling drugs from the children's house, and it is stored in a location that was easily accessible to a toddler and a baby, he put the children's welfare at hazard. And that conduct is a definition of unfitness. He also failed to benefit from services. He was put under a service plan in 2015. He continued to commit criminal activity well under a service plan. And most egregiously, he committed the serious criminal activity of drug trafficking after the pendency, during the pendency of the care and protection petition. So he failed to modify his behavior, and based on this recalcitrant pattern of criminal behavior, the judge was correct in determining that the father's would be his future behavior from that pattern of behavior.
Ms. Solins?
Yes.
Do you agree with Mr. Bayless that the judge erred in failing to consider evidence of the father's permanency plan?
I have a different view of how the court approached the plan. I think it's a mischaracterization to say that the father had no opportunity to present a plan. The grandmother was not available to testify when the court was ready to hear from her, despite the fact that she had been there for all 3 days of trial. The father made not a single mention of the paternal grandmother during his direct testimony. And he had no home study completed, despite the fact that this case had been pending for 2 years. The court gave him accommodations. The court gave him additional time to file that home study. The home study was never filed.
If we were to conclude that the case should be remanded for the purpose of addressing the father's permanency plan, and this is merely a hypothetical question,
Sure.
what would such a hearing look like?
Well, Your Honor, under adoption of DORA, there's a discussion about the fact that if the lower court feels that they don't have sufficient information to consider a plan, the court can postpone and have an additional hearing. I think the exact opposite happens here, in that the lower court judge decided she did have sufficient information to evaluate the grandmother. We have an unusual situation in that the father's nominated caretaker, the paternal grandmother, is someone who had already been awarded temporary custody of these children, and she had it removed. There is significant information about the paternal grandmother already in the record. And I think the judge was allowed to consider that. It notes in his decision, after reviewing the evidence and the testimony in the record, he declined to hear father's plan. And I think it was because she already had sufficient information to make that decision.
And not to harp on the procedures, but after the evidence closed, it was continued to a September date for the purpose of considering his plan, the father's plan.
Right.
It was continued again till the November 20th date for the same purpose. There's no record that I saw in the record of this case, transcript of what occurred on the 20th. So I don't know if it was, at least I didn't see a transcript, but I don't know if it was a matter of the judge saying, I don't want to hear anything, or the party's not being ready again, or asking for further continue. I don't know what happened on that date, and I don't know if it's in the record or not.
I don't believe that November hearing date is in the record, but we do know is that at the time of trial counsel for the father said she was not prepared to go forward because of no home study. Again, we see no home study in September when you see that no home study was ever filed in this case. I can't actually see my time.
It's 32 seconds.
Okay. I also think, and I'll just point out to my brief, that the father, I think, incorrectly asked to present his plan after his termination. And after termination, you no longer have the right to present that plan, but you were within the discretion of the court at that time, not as a matter of right. And that's what he asked to do. And I think the judge was well within her discretion to decide not to take further evidence on that point.
All right. Well, now your time has elapsed. Are there any further questions from the panel?
Not from me, thank you.
This case is then concluded, counsel. Thank you very much.
Thank
you.
Okay, we are live.
Thank you very much. This is the final case of the day, 19P 1642, Fritzman versus Fritzman. Counsel, you can proceed.
Thank you, Your Honor. My name is John Gallant. I represent the appellant in this proceeding, Karen Fritzman. I'll say from the onset that I have a tendency to speak quickly, so if the court doesn't understand me or can't hear me properly, just let me know. I will do my best to slow down. First is, the applicant will demonstrate to the court that the judgment and findings of a lower court are erroneous, are inequitable in application, and should be reversed on the sole issue of the retroactivity of the alimony issued in this case. We firmly believe that the judge made a mistake or a typographical error in his decision. He didn't intend for this order to be retroactive. He said so on the record throughout the course of this proceeding, even during the trial, and he made an error in his typing out of the decision to make it retroactive. All of the findings, all of his decision, all of the specific rationale of his case supports non-retroactive application of the alimony as opposed to retroactivity.
Mr. Gallant, can I stop you on that point for a minute?
Yeah, absolutely.
The suggestion that the error was typographical was before the judge, after the judgment was ordered, which obviously would have given him an opportunity to consider your argument and correct a typographical error. And the motion was denied why shouldn't we infer from that in fact it wasn't typographic?
Well, I'll demonstrate in my argument why, in order for this order to be retroactive under Keller versus O'Brien, and the cases cited thereunder, he has to make specific findings of its being retroactive. This judge, throughout the course of this entire case, indicated that he was not going to issue a retroactive order, and he stated why he wasn't going to issue it. The findings of his order are inconsistent. We filed a motion saying it was a typographical error, but he denied it without hearing. I haven't had the opportunity to go in front of this trial court and explain why his order is inconsistent and why it was a typographical error. He denied it without hearing based upon the papers. I haven't had the opportunity to appear in front of Judge McSweeney to point out to him that all of his findings are inconsistent with the order of retroactivity. Under the case
Attorney Gallant,
Yes.
Judge Lemire, I just want to procedurally, the trial of the modification, which resulted in this order.
Yes.
The court entered judgment on that in March 6th of 2018.
Yes.
You filed a motion under Rule 59 to amend, or in the alternative Rule 60 for relief from judgment on March 29th, and the court denied that on April 13th, and there's a question of when it was docketed, which was April 26th, according to the docket. It was then that you filed an appeal of the denial of the motion to amend. So it's my understanding we're considering only the judge's ruling on the motion to amend. You did not appeal. Is it your it's my understanding you took no appeal from the judgment of modification?
Yes, it's our position that we appealed the judgment of modification in this case. The motion that we filed to alter or to amend the decision would stay the period to appeal the modification, and that's what we did. Once that was denied within that time frame, we appealed the modification and found the notice of appeal of the modification, not just of the motion to alter or to amend. So let me address the issues of the substance of our case with regard to this case. Under Keller versus O'Brien, in this particular case, an order for retroactivity of alimony and support must be based upon specific findings of restitution. Retroactivity means that it has to be based upon principles of restitution where it's unjust for Mrs. Fritzman to have retained this money where she has to pay it back to Mr. Fritzman. In this particular case, it's erroneous as a matter of law based upon four clear established principles. The first is, in this particular case, he failed to consider the fact that Mr. Fritzman received his actual income of over $250,000 to $300,000 for a period of 6 to 9 months after the date of service. He made this retroactive back to the date of service, yet he was still being compensated and earned income over $250,000. He failed to consider the fact that during this time frame, she made substantial expensive payments towards a joint asset that Mr. Fritzman received half the benefit of. And he failed to enter an order for child support. He did, however, account for all three of these decisions if his intent was to make it non-retroactive. Let me explain. First, let me explain some of the facts of this case. Parties were divorced in 1991. They were married in 1991. They were divorced in 2000. They had 2 minor children, a son and a daughter. My client received custody and primary physical custody of the 2 kids and lived in the party's house and marital property in Groton, Massachusetts, which consisted of over a 6,000 square foot house. That title to that property was held jointly with Mr. Fritzman and Mrs. Fritzman. She had an obligation to list and sell that property when the youngest child was in his senior year. In the meantime, she had to maintain that asset by paying the mortgage, the taxes, the insurance, the maintenance, the snow plow, the landscaping spill, and pay child support. Mr. Fritzman's order in this case that was entered in 2000 for $1,100, it was an order for alimony. There was no specific order for child support. So that included both child support and alimony.
Well, was it just an alimony award?
It was just an alimony award, but the court made findings in its judgment. Judge McSweeney made findings that the amount of the order was an alimony support. No separate support was allocated. It's separate in paragraphs 6 through 8 of his findings. In this particular case, the Mrs. Fritzman retained custody of all 3 kids and primary custody at the marital home. The reason why this order, if you apply it retroactively, is if his intent wasn't for it to be retroactive, is erroneous as a matter of law. There's three specific reasons. First is he allocated $100,000 of income to Mr. Fritzman because he was substantially unemployed. After this complaint was served on December 8th, date of service, where he made it retroactive, Mr. Fritzman had a severance payment from his job where he made over $108,000 in severance payments. He made a specific finding in his order of the severance payments. And he was earning $250,000 to $300,000 for 6 of 9 months after the date of service. Yet he made this actions retroactive to before the time frame where he was receiving money. So rather than calculate his alimony and support based upon his actual income in that time frame, he did it based upon an attribution of income of 100, which was a third less than what he was actually making. That wasn't his intent. Secondly, the judge's intent to make it retroactive, and the more glaring reason why he clearly intended for it to be not retroactive is in his decision. In the paragraph where he makes it retroactive is paragraph G, page 2 of the judgment. In that paragraph, he says in the first sentence that the alimony will be retroactive to the day of service. The second sentence of that paragraph says, I find that the defendant had substantial expenses during the pendency of this modification, including expenses for the maintenance of the marital home, utilities, cable, repair, maintenance, children, and of which the plaintiff benefited from by receiving half the proceeds. In this particular case, she used the money that he paid her to pay the mortgage on the marital residence, the repairs and the maintenance of this marital residence. It sold in March of 2017, and he got all of that money back because he got half the proceeds, to some $256,000. The judge makes a specific finding that he got that money back and he got the benefit of the money that he paid. That's a finding that would support non-retroactivity as opposed to retroactivity. In addition, the other two.
If I may, counsel, just to go back to the first one, do we know in this record how long the severance period was for?
Yes, well, the severance period calculated based upon his annual income of $252. We've argued that it's for a 6-month period following the date of service.
I didn't ask you what the argument was. I asked if we knew, because there's got to be a severance document somewhere. Do we have that?
Yes, I do. The severance document was for $106,004. The specific amount was $106,406. We calculated it to be a
payable
6 months.
In a lump sum or over time?
Payment in a lump sum.
Okay, thanks.
And the judge made a specific finding of that. Even counsel for Mr. Fritzman admits that he received the money and was for a period of time continuing his income following the date of service. Second argument why this judgment is not intended to be retroactive is because of the finding he makes specifically that she maintained this joint asset. The third reason why is because nowhere in his decision does he make an allocation for child support, because he intended the payments that were being made to be an allocation of child support. In this particular case, there's no award for child support. He doesn't make findings for child support. There's no award for child support. And that's because he didn't intend it to be retroactive. If he intended it to be retroactive, the amount that he established of $330 a week did not include child support. He would have to make specific findings under Chapter 208, Section 28 for child support in addition. Otherwise, what happened in this case is the house sold. He received half the proceeds of $256. She would have to repay back $90,000 to $100,000 of her proceeds, which would, instead of receiving half the proceeds from the house, she'd receive 25 to 30% of the proceeds as opposed to 50%. He got the windfall, a double windfall in this case. He won because he got the proceeds back when the house sold, and he got a retroactive order. So she paid the money back twice to him, which makes absolutely no equity in this case. If his intent was to make it retroactive, there's not one finding in the order or in the judgment to make it retroactive. There's nowhere does he say it's unjust for her to keep this money and she must pay it back. It's absent. Instead, he makes findings to the opposite. He says it's actually good that she got this money because she used it to maintain this joint asset, which she received the benefit of. That's
Mr. Gallant, can I interrupt?
I'm sorry.
We're assuming, of course, that the judge was intimately familiar with the parties and the evidence in the cases, as his findings would suggest.
Yes.
When you brought back to him the argument that you're now making to us about what he really must have intended.
Yes.
And he ruled against you, how can we conclude that that was an abuse of discretion given his level of familiarity with the case?
Because it's against the law. Because In order for him to make that finding, he would have to make findings of restitution, and under Keller versus O'Brien, he would have had to make findings that it was unjust for her to keep the money. There are no such findings. In order for that to be justifiable and to be retroactive, he would have had to not make the findings regarding the payment of the joint asset and the actual income. Remember, in this particular case, Mr. FRITZMAN continued to make over $250,000 for a good 6 to 9 months following the date of service. Yet the application of this order retroactive would mean that he'd pay alimony on $100,000. He was making 3 times that. That wasn't his intent. That's not that. The language of his order clearly says that. It's not, I can't read into his denial of my motion, but I didn't get a hearing in front of Judge McSweeney. I asked for that motion to be heard so I could demonstrate to the court why his findings are inconsistent with the retroactive order. Under Keller versus O'Brien, on page 30 and 31 of my memo, he has to make specific findings that would justify the restitution of the war. Why this is unjust. Nowhere in his decision or his rationale is there one finding that keeping this money is unjust. In fact, in the same paragraph where he alleges that it's where he says it's retroactive, he makes a finding that says she should keep the money. He says during this period, she used this money to maintain an asset which he got the benefit of by getting 50% proceeds. Why would he make that finding in the same paragraph if he intended to be retroactive? It makes absolutely no sense. It makes this equities of this case so lopsided that she ends up with getting 25% of the assets in this case as opposed to 50% of the assets in this case. That's not what he intended. It's clear from his findings. Nowhere in his findings does he make the findings on page 30 and 31 of my brief. I said the O'Brien case and the case of Severance. Restitution is only appropriate on alimony and support if the circumstances of its receipt or retention are such that is between the persons, it's unjust for her to retain it. Nowhere in his decision is there any finding, one finding to support that. I asked counsel to demonstrate to the court, where's the finding that would indicate that it's unjust for her to retain this money that the court made in its decision or its rationale? It's absent. All of the findings support that it in fact should not be retroactive. He finds that he received the severance. He finds that she maintained a joint asset. He finds that the payment included child support. He doesn't include child support. As a matter of law, it's erroneous in his decision. If he makes it retroactive, he didn't make a child support order. Where is that? He fails to allocate that. I didn't get a hearing before the lower court demonstrate to him that these 3 things and these 3 principles, which he would have to make in his findings, are erroneous as a matter of law because he denied it without a hearing. That's the problem.
Well, counsel, you're asking us to vacate and enter the finding that it not be retroactive.
I am, or in the alternative, remand it back to Judge McSweeney on the issue of the retroactivity and the findings that he failed to make on retroactivity of the support, because they're absent on the record. He's got to be able to demonstrate to you on the appeal that there's findings to justify a retroactivity of the award under Keller versus O'Brien and the cases I've cited in page 30 and 31 of my brief.
All right, just you didn't request the remand in your brief, but
I didn't, but I mean, that's also within the powers of the court to either, we believe that it's clearly erroneous, the retroactivity of the order, and I've demonstrated why as a matter of law. It doesn't include child support. It doesn't factor in the payments to this joint asset, and it doesn't factor in his actual income during this period of time, which the court would be obligated to consider. And he did, if you reverse it, if you read this decision, under the premise that he didn't mean it to be retroactive, the order makes perfect sense. The rationale makes perfect sense. The findings make perfect sense. And that paragraph makes perfect sense. If you read it the other way, it makes no sense.
Counsel, thank you very much. Your time has expired.
Thank you.
All right, you may proceed.
Thank you. The court asked a very important question, which was glossed over by my brother in both his oral argument and his appeal. And that operative question is, what is actually before the court today? If you actually take a look at the notice of appeal, which is page 56 of the appendix, you will see that the notice of appeal is only on the denial of the post-trial motion. which, based on the timeline, could only be construed as a motion for relief from judgment under Rule 60B. I've raised this issue in my brief. I raised it in a motion to dismiss before this oral argument. The issue that I have is that many of the issues that my brother is now arguing before this court are not properly before this court. And I've asked for this appeal to be considered wholly insubstantial on those grounds because procedurally they're not before this court.
Mr. Hawks, let me ask you a question about that. Do you agree as a general proposition that we start counting for purposes of meeting a time deadline, not on the date that the findings are made, but on the date that the judgment is entered?
I agree.
Okay. So in this case, there was a denial of the motion to amend on the 13th of April, but that judgment that on that denial was not entered until the 26th of April. So isn't that the date from which we start counting the appellate timeframe?
I agree with you, Your Honor, but there would need to have been a notice on appeal filed on the underlying modification judgment within the statutory timeframe. There was not. And
Does
if you-
that apply if the rule, if this is treated as a Rule 59 rather than a Rule 60?
Then the notice of appeal would have to have been filed within 10 days, Your Honor, of the denial or the entry of the denial of the Rule 59. It was after that. So I've laid forth a pretty, I'd like to say, concise argument on that issue. So if the court considers this a Rule 59 motion, which you have the right to do so, then the appeal is time barred. The substantive appeal is time barred. If you consider it a notice of appeal filed on the 60B variation of this rule, Your Honor, then we're only dealing with whether or not it was an abuse of discretion for the court to deny the Rule 60B motion, post-trial motion.
Well, in considering that question of whether or not it was an abuse of discretion to deny the motion to amend the judgment as a typographical error, don't we also need to consider some of the underlying evidence?
Your Honor, I'm happy to deal with the substantive issues and I'll argue on that point. From my point of view, this judgment makes sense and it is not an abuse of discretion, and I'll explain why. Discretion is the bedrock of the Probate and Family Court. The Supreme Judicial Court in Pierce says that the court has the ability on a modification action to issue a retroactive adjustment to an alimony or a child support order. It makes sense because in every civil case that I've done, the prevailing party is entitled to statutory interest from the date of the filing. Similar to in that vein, in this case, my client overpaid $90,000 in alimony payments after this case took 2 years and 4 months. If the issue of retroactivity was eradicated, it was eliminated from consideration here, then this would engage or encourage dilatory tactics, recipient spouses to drag out cases because there would be no potential retroactive adjustment over time. Now, in this certain case, I can tell the court is both of these parties were financially blessed here to have over $1 million in assets throughout the pendency of this case. So, that is why the court did not issue temporary relief during the pendency of the case. I filed 2 motions to get temporary adjustment to the alimony based upon the job loss. If you actually look at the amended appendix, and again, this is the opposition that my brother filed to my motion to reduce alimony on a temporary basis. His argument is that it's premature because the evidence and discovery has not been conducted. So it goes without saying that his argument in defense of a temporary adjustment prior to the evidence and testimony coming in was that it hadn't been considered by the court, and since it was the ultimate relief being requested, it would not be fair to his client to grant the relief. It makes sense that where the court considered significant evidence, expert witness testimony, that the adjustment should have been made, that it is retroactive. I want to deal with this issue, if I can, with the home, because this is, again, my brother trying to twist and gloss over intrinsic facts here to mislead this court. The marital home was divided in the divorce agreement. My client, pursuant to the original divorce agreement, was entitled to 1/2 of the equity, but there was a cap of time, 5 years, for the wife to have the ability to refinance the home, to move the husband's name from the mortgage, pay him his equity, or failing that, the home would be sold. She failed to effectively do that within the time frame allotted under the agreement. I raised this issue in my brief. I was required to file a complaint for contempt, which the court ordered Ms. FRITZMAN to immediately sign the listing agreement to sell this home. It was not a precondition that the home be sold. The precondition was that my client was going to get his equity out of the property. They've attempted to double dip on this issue and say that he has to pay alimony, and now he got this windfall back from the sale of the home. That's not what occurred. He was already entitled to that division of assets under the divorce decree. 5 years elapsed. He wasn't paid. The court ordered her to sell the house. She delayed selling it beyond the time allotted, and my client had to continue to pay alimony. They've attempted to use this argument that somehow she needed this alimony order to pay the home. Their bad faith behavior in delaying this case for 2 years and 4 months should not be rewarded. It should actually be that my client is entitled to the retroactive adjustment. And the case law is clear that this court needs to consider whether or not the questions and the findings of fact that were found by the trial court were rational. And I think that they were. It became clear after the 3 days of trial that Mr. FRITZMAN was not earning what he was earning at the time of the divorce judgment. His income had significantly decreased. The court, in its very measured discretion, decided an imputation of $100,000, or an attribution, of $100,000 was appropriate. My client continued to pay alimony week after week after week until we got this judgment. He spent down his assets. Now, as I've laid forth before this court, you don't have an obligation to spend down assets to pay an alimony order. But my client did so. So it makes sense. Why would the only windfall that would have been in this case was if a retroactive adjustment was not made. So there was a material change. I don't believe that to be disputed by my brother. Yes, Your Honor.
Mr. Hawks, let me interrupt again if I could. Mr. Gallant suggested in argument that the judge several times during the course of the proceedings had indicated on the record that he did not intend for any adjustment to be retro. What's your response to that?
My response is the question, where is that in his brief? Where in the transcript is the statement from the judge that there's not going to be a retroactive adjustment? Had there been a statement by the judge, you can be certain my brother would have referenced that in the transcript. I can tell you my review of the transcripts indicates that at all times we were seeking retroactive relief back to the date of the case being served. And that's indicated by our repeated motions and my client's testimony under oath. Is that,
thank you.
Have any questions on that, Your Honor?
No.
Your Honor, I know it is somewhat extraordinary to grant attorney's fees in a complaint or an appellate case. But in this aspect, in this case, I find it to be appropriate, and that is why we've sought it. I find that the glossing over of the substantive issue about whether or not procedurally this is a time-barred appeal is an operative question. My client had to basically have a two-front war, so to speak. He was dealing with this appeal, and contemporaneously with that, Ms. Fritzman filed another modification seeking to increase her alimony in the trial court. For what it's worth, that was dismissed by the court. There was no adjustment to the alimony, and Ms. Fritzman was found not credible on 6 occasions in the findings. I know that's not.
Is any of that in our record?
It's not in the record, Your Honor, because I don't know that it's all that relevant to your decision.
Let's stick to what's in the record.
Yes, Your Honor, thank you. So, Your Honor, in any civil action, had there been an award to the prevailing party, that prevailing party would have been entitled to statutory interest. It should not, in this probate and family court, we should not reward behavior where a recipient spouse could potentially drag out a case in bad faith, despite knowing that the paying party has lost their job because there's no risk of the court having the discretion to issue a retroactive adjustment. I think had the facts of the case been different, had there been a disabled party, perhaps retroactive adjustment would not be appropriate. But if you look, Ms. Fritzman essentially was full-time employed during the case of the, during the pendency of the case. The judge attributed income to her in the amount of $50,000, found that she could be gainfully employed. I mean, as you can see from the financial statements, this is a person with well over $1 million in assets. So she was not in any harm financially by having to repay this amount of money. And quite frankly, I think that we need to be careful about taking away discretion from the trial court. This judge was in a unique position to have dealt with this case for over 10 years, okay? From the original case, the original judgment of divorce, through the modification and beyond. As far as the argument that this was some sort of a typographical error, there's nothing within the record that indicates that. They raised this issue in
Counsel, if I could, how would you then explain the second sentence in the argument? In the judge's ruling stating that she had made these expenditures on the marital home. What relevance does that sentence have given your interpretation of what the judge intended to do?
The relevance of the expenses on the marital home could easily relate to my client's expenditures on the marital home, because my client had to invest, and there's a finding and a fact in this, Your Honor, my client had to invest money on repairs to the marital home. Could the judge be missing the word notwithstanding? Of course. The underlying issue here, Your Honor, is that my client invested time and money in making capital improvements to this home, which were made findings of fact in this. He had to spend legal fees to get the wife to sell the home because she was already outside of the allotted time frame. Everything she did in this matter, and I think this is contained pretty clearly by the tactics in this case, was to delay. And I can report to the court that this issue was raised, the judge has made it clear, it was denied, and there is no underlying substantive issue here, Your Honor. This is solely on the 60B. Are there any other questions I can answer for this court at this time?
I have none.
I'm all set.
I really appreciate your time and attention this morning, Your Honor. Thank you very much.
Thank you.
Thank you. That concludes this argument, and it concludes our sitting for today. The panel would like to extend its thanks once again to all the people who made this virtual sitting possible. Thank you.
Thank you, Your Honor.